Good morning. This is CV 2025-015985, matter of Diaz et al. Versus Gutierrez et al. If counsel could please announce for the record.
Good morning, Your Honor. Jose Luis Chaiz on behalf of plaintiffs.
Thank you and good morning.
Good morning, Your Honor.
Go ahead, Paloma.
Good morning, Your Honor. Paloma Schieferstein of the law firm Snell and Wilmer on behalf of Wells Fargo Bank.
Good morning.
And good morning, Your Honor. This is Oscar Pimenez on behalf of defendants.
And good morning. Thank you to everybody for being here. We are here on a motion to dismiss filed by defendant Wells Fargo Bank, seeking to be dismissed from this action. The court received the briefing, which includes plaintiff's response. The court can give each side approximately about 10 minutes to present their arguments. Counsel for defendants Gutierrez, I didn't see anything filed. Do you anticipate arguing today or taking a position?
If depending on how the oral arguments proceed, I would reserve our right to address the court, but we don't anticipate having any opposition to the motion to dismiss.
Very well, thank you. Anything to take up before we start argument today?
Not on behalf of the plaintiffs. Yeah.
Not on behalf of Wells Fargo, Your Honor.
All right, thank you. As the Ms. Schieferstein, as the counsel for the moving party, you may begin. Again, you have about 10 minutes, and I can, if you want to reserve some time for rebuttal, that's just fine. Go right ahead.
Thank you, Your Honor. Wells Fargo is a stranger to the dispute at the heart of this case, which is an alleged oral agreement between plaintiffs and defendant Gutierrez. No claim is stated against Wells Fargo. Its joinder is unnecessary, and its continued participation only increases cost to all parties, including plaintiffs themselves. So some key points here is this is a title dispute between family members arising from an alleged oral promise made back in 2008, a promise to which Wells Fargo was not a party, had no knowledge of, and played no role in. The amended complaint does not assert a single cause of action against Wells Fargo and does not allege any wrongdoing on Wells Fargo's behalf. Wells Fargo is joined as a nominal defendant, but there's no legal theory here against it. And Wells Fargo's security interest in the property, its deed of trust, survives any transfer of title. And so Wells Fargo's rights are fully protected despite whether it participates in this case or not. So under Rule 19A, a party is necessary only if complete relief cannot be afforded in its absence, adjudication may impair its ability to protect its interest, or an existing party faces inconsistent obligations. And none of these conditions are met here. Complete relief can be accorded without Wells Fargo as a party. As previously stated, the dispute centers on an alleged oral agreement between plaintiffs and defendant Gutierrez regarding the purchase and title transfer of the property. Wells Fargo was not a party to that agreement, and if the court orders title transfer from defendant Gutierrez to plaintiffs, the deed of trust remains a valid recorded lien on the property, unaffected by who holds title. The deed of trust itself contemplates title changes, defining successor in interest of borrower as any party that has taken title to the property, whether or not that party has assumed borrower's obligations. Wells Fargo's interests are not impaired by its absence. Again, Wells Fargo's lien is perfected as of December 6, 2012, and runs with the property and under ARS Section 33411 and ARS Section 33806A. Case law also supports this. We cited Hogan v. Washington in our brief. And plaintiff's own authority supports dismissal. They cite Town of Gila Bend case, and in that case, the court found that joinder was not necessary when it involved construction dealing with the infrastructure of the party trying to be joined, and even there, the court found that joinder was not necessary. No claim is stated against Wells Fargo. The three claims here are performance, promissory estoppel, and unjust enrichment. With respect to performance, Wells Fargo was not a party to the agreement, made no promises, and undertook no obligations regarding title transfer. Promissory estoppel, Wells Fargo made no promise to plaintiffs of any kind regarding ownership, transfer, or financing. And unjust enrichment is Wells Fargo extended a loan in the ordinary course of its business and received payments to which it is contractually entitled under the notice and deed of trust. And importantly, there are no allegations within these counts against Wells Fargo. And then there are practical considerations that favor dismissal. Under paragraph 9 or section 9 of the deed of trust, it permits Wells Fargo to add reasonable attorney's fees and costs incurred in litigation to the outstanding loan balance. So Wells Fargo's continued unnecessary participation increases the financial burden on the borrower and potentially on plaintiffs themselves should they obtain title and assume the loan. So no party benefits from Wells Fargo's continued involvement. Wells Fargo respectfully requests that the court dismiss the amended complaint as against Wells Fargo, and no claim has been stated against it. Joinder is not required under Rule 19, and its security interest is fully protected regardless of the outcome of the title dispute. Its continued participation only increases costs of this litigation for everyone, including the plaintiffs. I'll reserve, and do you have any questions, Your Honor?
Not at this time, but I may, when I come back to you, you do have some time for rebuttal, if you'd like to use that time. Thank you very much, counsel.
Thank you.
Counsel, for the plaintiffs, I just want to make sure I understood your position, given the position that Wells Fargo has taken in this case, that they are not necessary. It's not necessary for them to continue to be a party in this case in order for the rights of the parties to be adjudicated here. And I wanted to hear from you.
Okay, thank you, Your Honor. Yes, our amended complaint based upon this court's order to include Wells Fargo began Wells Fargo participation in this case per se. Ultimately here, we believe that they are an interested party. They have an interest in this claim. Now, I pointed to the acceleration clause because that clause there specifically talks about and triggers a transfer and how that goes about and the consequences that can occur to basically the borrower in this case, which would have been initially the defendant for now. They are the borrower. They borrowed on two separate occasions. They made a loan modification on this home as well at a later point. Their interest there with this would trigger that, and that would also trigger my client in some form or another, because ultimately we now have a transfer of title. We have a perfected interest by way of the deed and the mortgage, and ultimately my client has to go about getting the appropriate financing to address that, or unless the court ordered that Wells Fargo provide them a good faith effort to analyze their situation and allow them to be financed by way of Wells Fargo. That is our position there. And as I said, because they have a interest in this property, they perfected the loan, they have the deed. Ultimately, this, whatever outcome happens, is going to, in one way or another, trigger at least that acceleration clause. So we do believe that they are an interested party in this, and don't believe that the parties could move forward and resolve this claim without their participation, Your Honor.
And I guess that's what I want to make sure I understand your position here, because I'm hearing from Wells Fargo that from their position, the court did order that Wells Fargo be joined in an abundance of caution to make sure that if there's an interested party out there, that they have an opportunity to have notice and be heard in this proceeding. But what I'm hearing now is that Wells Fargo, having had notice and opportunity to be heard, doesn't view its participation in this case as necessary or even or efficient for the parties' positions. And I guess I want to understand your position a little bit better as to those issues based upon what's being sought here, which is an interest in this property.
Okay. Well, I guess the court noted they did an abundance of caution. Our original position is that we believe that Wells Fargo was not a dispensable and necessary party at the juncture when we originally filed. And ultimately that was brought up by defense and the court concurred with them. And so that's why we moved forward to file a response on this point, ordered also by the court to do so. And so now we are attempting to defend that position based upon and respecting what the court wanted us to do.
Okay, anything further that you want to provide the court?
No, Your Honor.
All right, thank you very much. Counsel for for defendant Gutierrez and Sorzanco, anything from your end before I go back to Ms. Schieferstein?
Just briefly, Your Honor, I think the court, I'll go with the court's interpretation of the issue with joining Wells Fargo to give Wells Fargo an opportunity to present itself and protect its interests if it had an interest to protect. I think they're making clear that they disregard that they have an interest to protect because they have, their contract that they believe already protects them, and they don't necessarily believe that it's necessary for them to be part of the action. I believe that we're fine with whatever the court decides. If the court decides that in good conscience and equity we can proceed without Wells Fargo, that's the court's prerogative.
And it was your thank you to both counsel for reminding the court of the procedural posture here. It was the defendant who sought to have Wells Fargo joined. Is that no longer your position that Wells Fargo needs to continue to be part of this case?
Your Honor, initially we believe that, again, Wells Fargo should have had the opportunity to present itself and protect its interests. Just because they do have an interest, the property is encumbered by a mortgage, which Wells Fargo is the holder of that mortgage. So we believe that it was important for them to be heard. And if they had an interest to protect, as it's been in other cases from my experience, that it was important for the court to be able to allow them and for Wells Fargo to have an opportunity to appear and protect its interest if it so desired to. But I believe that's not the case in this case.
Thank you for that. And apologies, Ms. Schieferstein, I want to go back to counsel for plaintiff. There was an argument made that there hasn't in fact been a cause of action stated against Wells Fargo, and I wanted to make sure that appears to be the case from the court's review of the amended complaint. So I think that is something that should be addressed by counsel for plaintiff. I just want to make sure I understand your position in that regard.
Yes, Your Honor, that is right. We did not file a particular claim against them. I did not find a particular claim against them that I thought that I could, in good faith, make to the court. I just wanted to make sure to do what the court had requested me to do. And so I addressed those terms within the deed of trust that I found that I outlined in my response.
Okay, so there's no claim. I just want to make sure I understand the party's positions to make sure that there is what the dispute is here that the court needs to resolve through this motion to dismiss. I know that plaintiffs filed a response, but if there's no cause of action, I guess I just want to make sure I understand plaintiff's position as to how Wells Fargo should remain in the matter.
Well, with no claim, Your Honor, I don't believe they could be part of, because I have not filed a claim directly against them. As I said, Your Honor, I did this to make sure that I complied with the court, as well as amending my complaint to address Wells Fargo. But originally, we did not believe that Wells Fargo was going to be necessary for us to be able to move forward and get a ruling from this court based upon basically the internal triggers or internal protections within the deed of trust and mortgage documents, Your Honor.
Okay, thank you. And I don't want to. I just want to make sure I understand the party's positions here. But is there in fact I guess the court wants to first determine, is there in fact a dispute here regarding this? I know that there's a larger dispute in this lawsuit, but is there a dispute as to as the matter sits now, with Wells Fargo now having appeared in this matter and asserting in their motion to dismiss that they need not and do not wish to participate in this matter? Is there a dispute from plaintiff's perspective, or is there an opposition from plaintiff's perspective regarding the court granting the relief requested? I just want to make sure I understand that.
Yes, sir. There is no dispute and no resistance to a dismissal of Wells Fargo.
Okay. And Mr. Is that the same for Mr. Ruiz on behalf of your client?
Yes, Your Honor. We're in the same position.
All right, and Ms. Schieferstein, so it sounds like I want to make sure I'm understanding this correctly, because it may, I guess, clarify things and save the parties resources, or waiting for the court's ruling. It sounds like there's no longer a dispute that Wells Fargo can be dismissed from this matter without prejudice. Is that an accurate recitation of? Is that your understanding, Ms. Schieferstein? And then I'll go back to the other parties.
Yes, Your Honor.
All right, counsel for plaintiff, Mr. Chavez, is that your position that a dismissal without prejudice of Wells Fargo is unopposed at this time?
Yes, Your Honor.
And Mr. Ruiz, is the court understanding that correctly, that the dismissal of Wells Fargo without prejudice is unopposed at this time?
At this juncture, Your Honor, yeah, that's our position.
All right, very well. Then I'm not sure that the court needs to take this matter under advisement and issue any rulings unless there's a request for the court to do so. The court would be inclined, noting that the parties, after articulating their positions to the court, and thank you everybody for your time and for your efforts in that regard, have indicated that there is no opposition to the motion to dismiss filed by Wells Fargo, and the court would be inclined to dismiss Wells Fargo without prejudice in this litigation. Is there any objection to that?
No,
No,
Your
Your
Honor.
Honor, on behalf of plaintiffs.
Not from defendant, Your Honor.
All right, then the court will go ahead and without prejudice dismiss Wells Fargo, noting no opposition from plaintiff or other defendants. Is there anything else that the court can do to assist the parties with at this time?
Nothing further, Your Honor.
Nothing from defendant, Your Honor.
And
All right,
nothing
Ms.
from Wells Fargo.
All right, very well. Then the court will issue a minute entry confirming the parties' agreement or non-opposition to the motion to dismiss filed by Wells Fargo, and dismissing Wells Fargo without prejudice from this matter. And thank you very much to everybody for your time and for your efforts, and this matter is adjourned.